Herzlich willkommen, mein Name ist Carolin Emcke. Ich
A very warm
freue mich,
welcome.
dass ich Sie
I'm
alle
Carolin
begrüßen
Emcke, and I'm
darf
very happy
im
to
Namen der
welcome you,
Schaubühne und im
all
Namen
of
der
you, on
Bundeszentrale
behalf
für
of
politische
the
Schaubühne
Schaubühne and
zum
the
heutigen
Federal
Streitraum.
Agency for Political
Zunächst
Education. This is
einmal
the Streitraum
Ihnen hier im
of
Publikum, aber
today.
auch
And
allen,
by the
die
way,
im Netz
I
jetzt
need
gewartet
to
haben. Ich bedauere
apologize
sehr,
to all of you here in the
dass wir
audience,
Sie
but
haben
also
warten lassen.
to
Wir
those who are
hatten
following
die
us
Hoffnung, dass
online.
wir
We had you waiting
ein
because we had the hope
Video
that we
einspielen
could show
könnten,
you a
das
video
konkrete
which
Arbeit der
tells you more
Verifizierung von
about the concrete
Beweisen
work
online
of
nachvollziehbar
finding
macht. Das hat
evidence
leider trotz des Wartens für Sie jetzt technisch
and
nicht
dealing with it. And we tried to make it work, but it doesn't work. So
Adapter sind auch nur Menschen.
adapters are human beings only, as you might know. So please bear with me. We had to start belatedly. But we will talk about all these questions. We cannot show you the video, though, but we will talk about these
Die
questions.
heutige Veranstaltung steht
No
unter dem Titel
worries.
Krieg und Strafjustiz.
War and
Allzu
criminal
oft
justice
bleiben
is the
Kriegsverbrechen,
title of
Verbrechen
today's
gegen
event. All too often, war crimes and crimes against humanity remain without consequences for the perpetrators and their regimes. All too often, no one is held accountable for sexualized violence and torture in violent conflicts. What opportunities does the international criminal law offer to hold perpetrators accountable? How can facts be collected and verified? How do regional, national, and international conflicts differ in terms of what legal clarification is possible and realistic? What can we learn from looking at Syria, Ukraine, Israel, and Gaza? What do criminal proceedings mean for traumatized victims, survivors, and their families? This is what I want to talk about today, and I'm happy to welcome my guests. And I can also tell you that this event is being translated simultaneously, and I would like to thank our interpreters, Julia Wadecki and Lilian Astrid Giese. Thank you very much. They are sitting behind me, backstage. You can't see them, but you can hear them. They are invisible but indispensable. Now, let me introduce my guests. Marija Ristic. Born in Pristina in 1984, she's an investigative journalist and currently manager of Amnesty International's International Crisis Response Program. She heads the Digital Verification Corps, a network that supports AI teams in documenting human rights violations and digital fact-finding. Before joining Amnesty International, she was the executive director of the Balkan Investigative Reporting Network, a leading non-profit media organization in Southeast and Central Europe. Under her leadership, the BIRN, Bern, has won numerous awards, including the European Press Prize and the Press Freedom Award for Reporters Without Borders. A very warm welcome, Marija Ristic. And then I'm also happy to welcome Andreas Schüller, born in Viersen in 1979. He's the head of the International Crimes and Legal Accountability Program at the European Center for Constitutional and Human Rights, ECCHR, in Berlin. At ECCHR and as a lawyer, he has worked since 2009 on issues including drone attacks and the U.S. torture program, war crimes committed by British soldiers in Iraq, and international crimes in Syria, Gaza, Sri Lanka, Colombia, and Ukraine. He's active throughout Europe in national criminal proceedings based on the principle of universal jurisdiction, as well as before the ICC and the European Court of Human Rights. A very warm welcome to you, Andreas Schüller. Today, we will talk about accountability and war crimes and the question what to do about impunity and what we need in terms of witnessing and evidence in the procedural laws. And I would like to also tell you that we will try time and again to focus on concrete cases in order to talk about these aspects. However, we won't focus on one singular or individual war. And it's not only going to be about the Russian war of aggression in Ukraine or drone wars in Pakistan or Yemen or Israel and Gaza, but we will talk about the systematic aspects. We will talk about these aspects and themes in order to apply our conclusions to individual conflicts and cases. And I would like to focus on three fields, if I may say so. First of all, I would like to talk about concepts and norms, legal norms. What are the norms we know in this field of criminal law and the war? And secondly, I would also like to talk about truth and lies, about research and evidence, investigation and fact-finding. How do you collect facts and evidences, and what are the difficulties you encounter? And then we will talk about the law courts, like what tribunals do we have, what courts are to be involved, and how do they deal with different types of crimes, and what does all this mean for the victims if there are trials or if there are no trials. Let me start off with a very private question, if I may. We've heard a bit about you when I introduced you, and I would like to start with you, Andreas Schüller. What wars have you followed as an observer in your work or otherwise? And also because I would be able to say so for myself, whether there is one war which has concerned you especially or more than the others. Well, thank you for inviting me. And of course, this is a somewhat open question, because you have mentioned a number of conflicts, and I've been involved actively in dealing with those conflicts and wars. I mean, our work consists of looking all over the world at what happens. We are closely collaborating with human rights organizations and people who are personally concerned and affected. So Sri Lanka 2009 would be an example I would mention here, especially since people do not really know what happened there 15 years ago, especially in the final phase of the conflict between the Tamil rebels and the Sinhalese majority. So that was the time when I started working as a lawyer in 2009, or when I started working for the international human rights organizations. And I mean, you know, it takes decades. That's what we know from the cases we've been dealing with in Germany. In 2011, we already started looking at Tunisia, Egypt, Syria, Palestine too. We worked a lot on Syria at the time. But also the conflicts in Latin America have been conflicts we looked at. Now for me, and this has been a motivation for me in my work, it's been also very important to look at Western nations and the crimes they commit. I mean, this is certainly the generation I'm part of. 9/11 in 2001, the reaction of the United States in view of the terrorist attacks in New York and Washington, Guantanamo, the CIA kidnappings, the war in Iraq in 2002. So these have been themes I've been dealing with. It's not one conflict, it's actually a global conflict. And I've often looked at this particular conflict or conflicts also from the legal perspective, because it's really difficult to do something here judicially spoken, or you really have to try hard. It's a major challenge. It has been a major challenge for me. Now, Marija, Ristic, for you also the same question. What conflict regions or which conflicts have you accompanied in your work? What have you worked on? And also for you, the question, was there one which concerned you especially or affected you most, more than the others?
For me, that is also a very, let's call it a personal question, because I do come from the region that was in war or wars. We still don't have an agreement whether it was a one war or many wars. So I was born a bit before the war in now what is called a former Yugoslav Republic, Kosovo, but I belong to the Serbian community, and all my life I lived in Serbia. So in a way, wars and war crimes have always been part of my life, and I willingly choose that this is also my professional part, beyond being it very personal. So most of my career, I actually worked on former Yugoslavia. So I worked in all countries on all war crimes. So I worked primarily in Serbia, but I also worked in Croatia, Bosnia and Herzegovina. I worked in Kosovo, a bit North Macedonia. And there I followed many, let's say, venues of justice. I followed proceedings of war crimes in local courts. I followed the international courts, couple of international courts. And I did that as an investigative journalist, which is a bit different from what I do now. And then I decided I'm a bit, I felt in a way very helpless and hopeless. So I decided to move to other wars. So this is why I joined Amnesty. I felt that there is an expertise from former Yugoslavia.
Can I just briefly interrupt?
Yes.
Entschuldigung, sollte ich auf Deutsch sagen, aber es hat natürlich eine gewisse Komik, dass man aus Gründen der Hoffnungslosigkeit zum nächsten
It's a bit strange that for reasons of hopelessness you move to another war region.
That out of hopelessness you moved on to the next war zone. But I get it.
Absolutely. This is very strange. So I am in general a very optimistic person, and that's why I work on international justice, because I really believe in it. However, I'm also very critical. So I also know when things can't move and that they're stuck. So this is where I felt like that I put so much effort, 10 years working on this field in former Yugoslavia, and I felt nothing has been moving. Things are not progressing, so I felt that my work is not contributing, in a way, to the process of justice there. So that's why I was like, well, maybe in some other regions there are venues for justice, or there's a way to do it that is not journalism only. Because as you know as well, with the journalism, you report and your story is out. But what happens to that after, you don't control. With Amnesty International, I had a feeling that I work on my research, we produce something that is focused more on evidentiary standards, which are a bit higher than in journalism. And then there are my colleagues who work in the advocacy. There are people like Andreas who will move these cases forward, and there will be, let's say, more tangible justice. And in Amnesty, I worked a bit on Ukraine, I worked on Sudan, I worked now obviously on Israel and Palestine since October 7, almost every day. But I also work, and I think that's also worth mentioning, on countries that are not considered war countries like Iran, but we do have international crimes committed. So we do have crimes against humanity, but not the war as such.
Okay. Vielen Dank erstmal. Ich will vielleicht auch ergänzen.
So maybe let me add why this question was so important. I am naturally assuming that all conflicts have to be investigated in a similar way and that the same standards and same norms when it comes to fact-finding need to be applied. But I actually know this from myself, that sometimes you cannot really help that one specific conflict is a conflict you are especially affected by. For me, it was Colombia. I presume because nobody really imagined the violence and the extent of violence that I had to witness. Nobody who said goodbye to me before I left to Colombia and said, well, a lot of success for you. And this, therefore, has to do with the fact that this was a conflict that was invisible and the violence that did not receive any attention. So this kept me busy trying to come to terms with this asymmetry in my work. It is not an asymmetry of standards. It is not an asymmetry of the norms that one would apply oneself. So you already mentioned that there are different norms and principles that can be used. And first of all, I would like to ask Andreas Schüller. So maybe you can tell us, what are the norms, what are the concepts the international justice is using, and maybe I could also determine the order you should speak about this. And I will tell you afterwards why. So maybe you can tell us what we are talking about when you're talking about war crimes. War crime is what happens in war. And since 1949, we have the Geneva Conventions, and we also have additional protocols. And this is the core area of which the states agreed on what is allowed in war and what not. So international humanitarian law is the overarching principle, which has the kind of purpose of making war more humane, if you will. And we also have law in armed conflict, as it is called in English. And when there are serious violations of individual norms or regulations, then this would be a war crime. So it's not Iran where we're speaking about systematic human rights violations, but we're speaking about armed conflict and what happens there. And this has to do with how war is organized and how the civilian population is treated and individual regulations pertaining to this. So what is allowed and what is not. And not every violation of international humanitarian law would also be war crime. Only the most severest violations would be laid down in the Rome Statute, maybe with the International Criminal Court, for example. Can you give us a few crimes or spell out a few crimes, describe them specifically that would count amongst those war crimes? A war crime would be torture, for example. Air raids, but this is a highly complex topic because air raids that target civilian objects or civilians are also war crimes. The use of specific types of weapons are war crimes, chemical weapons, other types of weapons. So it is a relatively broad range, and at German courts there was sentencing because of the desecration of bodies or posing with bodies for photos. If soldiers surrendered, they also have to be treated fairly. If they are mistreated, then this is also a war crime. So you're allowed to kill soldiers while you're in belligerent activity, but not when they surrender. Then you have to treat them fairly. So these would be a few examples of what is allowed and what is not. So in the context of war crimes, let me speak about two aspects that you already mentioned. And let me pick out individual aspects. So you said, for one, that these are norms that play a role in war. And the second aspect would be civilians. So let me start with the first aspect. There is a basic differentiation between what could be reasons to start a war or enter a war, and what happens during the war itself. There we have specific conditions that might be used to classify specific forms of violence or specific actions that might be acceptable in war. Maybe you can tell us more about this. This is an essential distinction, yes. So first of all, the question is, are you allowed to enter a war? For example, last year, the Russian aggression major offensive in Ukraine, 24th of February 2022, this is a violation of the non-violence norm in the UN Charter. So this is the ban on violence in the UN Charter, and therefore it is a crime of aggression, as it is called. So the question is, with regard to international law, would a country be allowed to attack another country? This, of course, has to do with the right of self-defense, which would constitute an exemption, or if the UN Security Council would also adopt coercive measures, then this might also legitimize or justify an attack on another country. And what happens in war then has to do with international humanitarian law, international criminal law as well. And in order to spell this out very clearly, because in recent days, I don't know how I can word this in a neutral way, but there was quite some uncertainty around this, if I may say so. These are two entirely different matters. So one would be whether there is a right to self-defense in the case that one is attacked, or the right to resistance when you are attacked. There might be, different ways of wording this, but normatively speaking, this would be the same concept. That is, somebody is being attacked and tries to defend themselves. So even if there's agreement on this description, or if this description is unique, as is the case for the Russian war of aggression against Ukraine, still, for the parties that are in the mode of resistance or self-defense, these norms apply. Maybe you can explain this, maybe using the example of Ukraine.
Genau, also es gibt diese Normen, die das Kriegsgeschehen humaner machen.
There are those norms that are supposed to make war more humane. This comes from the 19th century, where we had battles where this was completely unregulated. For example, Solferino, this was the starting point of the Red Cross movement, where soldiers were just left on the battlefield and they just bled to death and nobody looked after them. And this is why this always holds true for an armed conflict. It always applies, and it applies to everybody involved in this war. Yesterday night we had an event on Ukraine, and there the question comes from the Ukrainian side. We were attacked. This was against international law, attacked by Russia. This was a violation of the ban on violence according to the UN Charter. And this stipulates that no country should exert violence against another in the form of an armed attack or occupation or annexation even. But still, Ukraine needs to respect international humanitarian law when it defends itself against the Russian forces. So, simply because they were attacked, and this was against humanitarian conventions, they are not allowed to do whatever they want. You still have these legal norms that apply to all warring parties. So, according to international humanitarian law, Ukrainian soldiers may be killed during war, and they cannot defend themselves with all means against this. So, again, this is asymmetrical. When you are being attacked, you did not want this war, and you have to defend yourself against it. But it is still important, in order to not have the war escalate, that we have this legal framework. Everybody needs to respect, even though the other warring party might not respect this framework at all. You might think that you don't have to respect it either. I understand that it is not simple and not easy for different reasons. So first of all, I think it is important that we discuss the different principles, concepts, and norms, and then we can use different examples or different cases in order to explain them. But I believe it is absolutely important to highlight that this is not only about who was attacked and who can legitimately defend themselves. Even for the party that defends itself, there are norms that are binding. So if I use this example, Russian prisoners of war cannot be tortured, civilians or civilian population cannot be attacked either. Maybe you can say something about this as well. What is the role of the differentiation between combatants and civilians? This, of course, is an essential distinction. Who is a combatant and may be attacked in war? And who is a civilian, or what is a civilian object as opposed to a military object? This is the basic distinction in humanitarian international law. So it determines what is allowed and what not, and who may be attacked and who may not be attacked. As always, there are gray areas. There are specific considerations that have to be made. For example, in the context of a non-international armed conflict, it is different compared to an international armed conflict. Ukraine-Russia is international, but we know other cases, for example, from Syria. This is a non-international conflict. It takes place on the territory of one country, and we have non-state actors and state actors. They fight against each other. And on the non-state side, we don't have combatants. We have civilians who participate directly in hostilities. This is what it is called in international humanitarian law, so they are equal to combatants, and this is why they are being attacked. But the question is this an active participation in hostilities when you go to bed at night? Are you somebody who can be attacked or not? And for drone attacks, this was a big issue. Who is part of the non-state actors? Who is part of this group? This is where it becomes a bit unclear. And for civilian objects, a hospital that is also used for military purposes. So the hospital is not only defended with security personnel, but within the hospital there is a conflict party or a party to the conflict that has a separate wing, and this is where it puts up a military headquarters because they think it is a protected object, and if they operate from this, it is more difficult for the enemy to attack this object because it is actually a civilian one. So the question is, from when on, for which time duration, and to what extent would this object lose its status of being a civilian object and may be attacked? So this is down to the fine details of the definition, and this is why it is so important to gather evidence and investigate facts in order to be able to assess this. But even though while the war is ongoing, the parties need to assess this in real time, and we can only look at this in hindsight. It is a bit unfair, but when it comes to the norms and matters pertaining to this, I would like to continue to ask Andreas Schüller. For one, you have the status of a civilian person or civilian population. And I would like to hear something from you about the attacks of Hamas and Islamic Jihad on the 7th of October in Israel. They were not only on military posts or personnel, but they were essentially attacking civilians in different places, in different kibbutzim at the border to Gaza. So, I would like to have your appraisal whether any element of these attacks could be called legitimate resistance, self-defense, and could be described in that way.
Now, that gets us back to an aspect we mentioned before. You have certain rules that apply in an armed conflict for all parties involved. On 7th October, and nobody disagrees, a number of civilians were attacked. They were killed. They were taken hostage. They were raped. All these are violations of the humanitarian international law. Thus, there is no justification for these acts, because in an armed conflict, this is a clear violation of the legal norms and standards that apply, and this is a war crime. I did not have any doubts. I just wanted to hear from you whether you confirm. And I think this is also one of the missions of an event like the one we are having here today. Like, we have to look at such claims, we have to analyze them, and we have to compare them with the standards and norms we have. And please bear with me, I will ask such questions repeatedly today. This is not an expression of my own doubts, but I think this is what the public has to do. We have to use the concepts we have. We have to apply our legal categories to different conflicts and the different conflict parties. And these are the concepts, and the universal norms have to be applied. The second aspect would be one concerning the state of Israel and its reaction in view of those massacres, the massacres of Hamas and Islamic Jihad, in terms of a legitimate act of self-defense. And as you said before, there are difficulties when it comes to the definition of who a civilian is, but I need to ask again. The civilians, the civilian population, the civil population in Gaza, in the Gaza Strip, could they be seen in the context of this self-defense, or do they have to be protected, and can they be protected by the international humanitarian law? Now, once again, protection according to the international humanitarian law applies to all conflict parties, and that includes the civilian population, and thus also the civilian population in Gaza. They are protected by the international humanitarian law. protected against attacks from Israel, as Israeli civilians are protected against attacks from the other side. Now, the fightings and the hostilities, as it says in the law, requires the protection of the civilian population. And whatever happens on the spot is to be judged and assessed according to these standards. As I told you before, there is a lot of uncertainty, and I'm not really sure whether we can solve this problem, because it always depends on who is attacked and what are the targets. Does the Israeli army attack civilian targets or military targets, or is it a mix? This then decides on what can be done legally. Now, I'm not a lawyer, I'm not a legal expert, but there are the protocols with the Geneva Convention, which also make statements concerning the gray zones, i.e., they pertain to war or warlike situation in which it's difficult for the combatants to distinguish between combatants and civilians. So please put me right if I'm wrong. But I think that in the annexes, it clearly says that in case of doubts, if the situation is not clear, the persons in question need to be considered civilians. Yes, everybody is a civilian until the contrary is proven. That's the fundamental principle. So in case of doubt, every person is a civilian. Sorry, I'm losing my mic here, but I need sound, so please. One more aspect which is very confusing for me in the coverage of all wars. When talking about the civil population or civilians, people tend to think that only women and children are civilians. I mean, that's the impression people have. I mean, if you read the articles or listen to the reports, I have the impression that also in the images which are being shown in the documentation, it has to be underlined that civilians are concerned, but it's always about women and children, that men can be civilians too, seems to be overlooked per se. They seem to be combatants. Is there a logical reason for it, or is it just bad coverage? Now, let me say the following. There are certain protective norms for women and children and the elderly in conflicts, because people assume that they are not part of the conflicting parties and that they are civilians. But this is, of course, per se not a given. And of course, you have to check whether they are members of a conflict party or not. I mean, if it's about the army, and then it's quite easy to see whether women are part of it or not. But in the case of not regular or irregular fighting forces, it's a bit more difficult to see whether women are part of the fighting side or not. So then it's more difficult to decide who is involved in the immediate hostilities. But then, on the other hand, it can be everybody. So women and children could be part of it too. So there's a certain bias. Also, when it comes to drone attacks, so in the case of drone attacks, they check whether there are men who could be combatants, i.e. men between the age of 15 and 50, who are different from women above the age of 60. But as a rule, everybody can be a civilian. Maybe a last question with respect to the norms. I'd like to ask about genocide and how genocide is being defined. And I'd like to also hear concrete examples so that we know what a genocide is. Now, this concept was developed after World War II. There is the Convention of 1949, and then you have crimes against the humanity, which could be seen as a parallel, which also considers certain groups and certain characteristics, so to speak. So in the case of a genocide, there needs to be an intention to destroy a certain ethnic or religious group. And it doesn't have to be murder only. It can also be rape. Or you limit the rights or possibilities of a certain group. So there are different ways of exercising the genocide. And the Genocide Convention, which is called Convention for the Prevention and the Punishment of Genocide, starts much earlier. So they also consider the aspect or the situation before a genocide happens in order to prevent a genocide from happening. So it's not like genocide, yes or no. This is genocide, yes or no, but there are different stages in which countries are obliged to undertake certain measures in order to prevent genocides. And then if a genocide happens, it has to be punished. Two follow-up questions here. The category of the intention. I mean, I don't have doubts that there are enough conflicts and genocides where the intention was clear. Rwanda would be such an example, where it was evident there were claims and demands and appeals and a very long process, which led to the act, and the intention was even verbalized. In the case of the Rohingya in Myanmar, I'd say the same can be said. The intention is visible, and there is also evidence and documentation. Nevertheless, we could go and say this is really a very high barrier, so to speak, in the international criminal law, because regimes could also go and say that, I mean, regimes could also go and commit genocides without ever declaring an intention. So what is the purpose of the norm, which implies this idea of the intention? Why is the intention part of the legal norm? Well, there is genocide and crimes against the humanity, which is the same in the legal context. I know that genocide sounds differently if you use this concept in a political context. But this is about crimes committed against certain groups because of particular characteristics or features of the group. And it's much more difficult to prove that a genocide has happened or is happening because you need the intention. If there is no intention, or if it's not quite clear whether there is a real intention to act against a certain group, it's getting complex. I mean, you still have the potential crime against the humanity, like the persecution of a certain group, and there is less intention required in order to constitute the crime here. So even if you cannot prove an intention, you can deal with a crime against the humanity. So it's a system with different stages, or a norm which has different levels, so to speak, in order to be capable of persecuting genocide with the intention, which is the top tier, so to speak, and crimes against the humanity in a different context. One more question before I talk about the evidence side. Because This is not about a genocide committed only, you say, but it's also about a certain dynamics. I mean, what is happening, what do we see, and what are the legal categories we can apply in order to prevent this genocide from happening in the first place? Could you briefly comment on this particular aspect? Because this is also about the possibility to bring justice or to bring the cases to court. Because right now we are talking about Gaza, for example, and the question is, can it be called a genocide? There is a pending process in this respect. We will talk about it later. But maybe you could briefly comment on the fact that this is not only about the question whether a genocide can be stated here already.
This is exactly the point. With international criminal law, you're always a little late after the crime already happened. But of course, you want to prevent the crime in the first place. This is sanctioned because of the fact that calling for genocide is already something which is punishable. And this prevention, and as I said, there are many different steps, and this is why the court proceedings are so important to analyze. You need to check whether a first level has already been reached, or is this level 2, 3, 4, or 5, even though there is no exact number of levels. And the higher the level, all states or the international community needs to take measures in order to prevent such a genocide from happening. And I believe that these are very important points to discuss. We need to check where exactly we stand. If we look at this 10 years from now, trying to analyze what happened 10 years ago, we will be in a better position, but it does not help us right now. And this is why it is very important to categorize and then also to have measures follow suit. So I apologize, but I really had to, first of all, make sure what the definition of the principles is, and this is very important in order to then be able to understand how investigation works, how research works. And we had the hope we could use a video in order to show this example and illustrate this, but this is unfortunately not possible. So Marija Ristic, I would like to ask you, what kind of sources, what kind of information do you actually use in your work for Amnesty? Or what is the information that you have?
So I think that really depends on context. There are obviously some golden standards of what is the ideal situation. We in Amnesty always and foremost rely on witness testimony, so that is still something that we always try to do, and I don't think we published anything without the witness testimony as such. But there are situations definitely where the witness testimony is very difficult to get because we don't have access to the certain country. And also in many cases, you either don't have witnesses or you can't reach them immediately, but you do have videos, images, satellite imagery as well, which is basically a satellite image from filmed by a satellite. So these are our, let's call it, primary sources. And in modern conflicts, this is something that we first get. In many instances...
The video.
Exactly.
Yeah.
In many instances, we find about potential crime actually through images and videos. Only later we reach to witnesses. And for people who followed conflicts before, like me, you would first hear it from the witnesses, and then later you would find out about that online. Currently, it's the other way around. So you find out online that there is a potential crime, and then you look for people who can actually corroborate your digital evidence. Mm-hmm. Because the digital evidence is overwhelming, sometimes it is very powerful. So you can conclude, let's say, 80% of how events unfolded, what happened, who did what, who launched the specific weapon, in which direction, at what time. But then very often you do need corroboration with witnesses who can tell you how this reflected on the ground.
Könnte ich Sie fragen, wenn Sie vergleichen würden?
So if you would compare,
Sie haben beschrieben,
you
Sie
described
haben ursprünglicherweise
that
immer einen
originally
Fokus gehabt,
you always had a focus
biografisch,
on
auf den Kriegen im, ich
wars.
sage jetzt mal Plural, aber
I'm saying this in the plural now, in the plural form, but wars in former Yugoslavia, also because of your biography. So if you compare the way
Kriegsverbrechen,
in which
Verbrechen gegen die
war
Menschlichkeit,
crimes or crimes against humanity were documented then and there, and compare this to Ukraine and Russia
heutigen Fall nehmen,
as a current case. In how far is this different, and in how far is your verification different?
So former Yugoslavia was still a war that mostly relied on witness testimony. And most of the evidence of the war crime actually came from witnesses. We didn't have photos and videos and digital verification how we understand it today, but we did have journalists. So the journalists were the one who did, let's call it like the first, how it's sometimes referred to, first draft of history. So the journalists were the one who were taking photos, talking to witnesses, and they were recording what is happening. Depending on which war it was in former Yugoslavia, journalists would have a different type of access. So sometimes they would speak with the victims and refugees in one country, but very often they wouldn't be allowed, like the situation in Kosovo. Journalists were not allowed, except Serbian journalists, to be in Kosovo, but people were interviewed in Albania, where the refugees were. So this is how and me myself, because I worked after that, so I didn't work as a journalist during war, I worked as a journalist reporting on wars after and documenting different war crimes. So my basis for research was always what journalists reported during war. And then, this is very strange to say for someone from former Yugoslavia, but we were lucky that we did have a lot of international and local courts. So a lot of documentation there exists. So for example, international court would look into one crime, but they would gather so much evidence that you can then pick up and investigate other crimes, which is what I did most of my career. So most of the documentation was actually, now I call it traditional, but it is like witness testimony, different reporting, also human rights organizations, local human rights organizations. And now it is completely the other way around. Now I work with the team that is mostly focusing on the digital testimony, but digital testimony, it could be said, digital evidence, and we then corroborate with researchers. So now what we do is we gather immediately everything that has been published online or that we can gather from witnesses. They send us images and photos. And then we try to verify that content.
Könnten Sie ein bisschen spezifizieren, was
Maybe you
für
could
Art
specify
von Videomaterial
what kind of
es ist?
video
Das
material do
eine
you
ist
get?
ja das, was über soziale Medien
So one type
von
would be
Zivilbevölkerung,
that
aber natürlich
you
auch
get
von
via
Kombattanten
social media from
posten.
civilians, but also from
Aber das
combatants.
andere
They would
sind
also
ja
post
auch sehr
material,
viel Videomaterial,
but you also have a lot of video material, I presume,
was CCTV footage ist.
that is
Also,
CCTV footage.
Kameras, die installiert
So
sind an
cameras that are
Straßenkreuzen,
installed
in,
at
Geschäften.
crossroads,
Können Sie ein
in
bisschen
shops.
etwas sagen
Can
zu
you
dem
tell us something
unterschiedlichen
about the
Status
difference
von dem
status
digitalen Material, das
of
Sie
the digital
anschauen
material that you
und wie Sie es dann
analyze,
auch verifizieren
and how
oder
you
wie Sie
verify
damit
this,
arbeiten?
or how you work with this?
Vielleicht am Beispiel, also nehmen wir mal das Beispiel Ukraine.
So,
Let us take the example of Ukraine.
maybe I can start with the CCTV that you mentioned and also building up on what Andreas was speaking on the October 7 attack by Hamas. So this is where we relied a lot on CCTV footage. That was our primary footage, and then footage from the people who took part at the festival, and then they were posting images online. So in both of these instances, actually both CCTV footage and footage from the social media posted by the participants of the festival were crucial to establish what happened on October 7, and it is clearly extrajudicial killings, torture, abductions that all are punishable. So the key thing with the digital verification is to be transparent. How you got the evidence, who is the owner of the evidence, and what this evidence tells us. So that is, I think, the most important thing that everyone should follow. When I say to be transparent, that means that we would always need to know who is the person who created this evidence in ideal circumstances. So we need to understand what is in the legal language called chain of custody. So who is the person who created this evidence? Very often, that's not possible. But we need to understand, in that case, when it's not possible, who is the source. So who is the person who posted it, and whether we can assess that evidence with credibility. And you mentioned combatants. They often post videos. So we would rarely, for example, rely on videos from combatants as primary evidence, but we would use it to corroborate other evidence. Our primary, in essence, what I think sometimes there is a lot of, I would say, not clear understanding what is like a digital evidence and who are the people. But basically, I think in very simple term, that is your digital witness. So you are still looking for a witness of the crime. It's just that you don't call this witness or you don't interview that witness, but you actually look into the video that a person who is a witness of the crime created. So this is all, let's call it, ideal. In some circumstances where there is a possibility, which was, for example, not October 7, but there were some other cases like Mariupol in Ukraine, attack on a theater, or the case of the journalists being killed at the border with Lebanon, you do have an overwhelming amount of digital evidence, and you are able to determine exactly, on the basis only of that, who fired, which army fired at the certain position, which army is responsible, and which weapons they use. Like, you can even go to the details to determine what was the type of weapon and what was the military that used it.
Das wäre jetzt genau der Moment, wo Sie sich dieses Video vorstellen.
So this would be precisely the
können.
moment where you have to
Vielleicht
imagine
können wir
this
das an dem
video
Mariupol
tape or the film. Maybe we could use the Mariupol example, and maybe you can just verbalize this for us. What kind of material, what kind of footage did you have, and what kind of questions did you ask? What type of skepticism do you have to apply when you use this footage? And maybe you can also go into the technical details if you like. What can you actually verify when you use this evidence? And what methods are there to maybe fake this evidence? How can you detect these lies or disinformation campaigns? And what are the uncertainties or the insecurity that is left?
Yeah, so on Mariupol, I think one of the distinction of that specific event was one, of course, we did had a lot of videos posted online. So if people remember and if they have followed, people were posting recordings from the theater itself. So a lot of the people who were hiding in the theater, they were posting videos of the situation in the theater. Then At one point, right before the attack, there was also a satellite imagery posted by a satellite company that owns the satellite over that territory that showed us that in front of the theater there was written deti, which it means children. So there was already, in a way, we had information that there were children there on the basis of the satellite imagery, but also on the basis of the images and videos that people posted who were inside.
Okay, wenn ich nur ganz kurz, if I may, ich sag ganz kurz Englisch, weil da musst du nicht immer die Kopfhörer absetzen.
So let me just quickly speak English with you.
Just to add, of course, there is also the possibility that somebody just writes on the pavement children where there is, you know, heavily armed combatants inside the theater. So just to say, you need it, because that's important. You had both info. You had the video from inside and the text outside.
Exactly. And then what happened after is that we knew that the theater was struck by a big bomb. We, at that point, only knew that it was a huge bomb and that the part of theater was destroyed. And at that point, there were also not clear numbers of how many people were there, how many people were killed. Our next step was to try to look for survivors by phone with the help of our colleagues in Ukraine. And then the survivors were sending us images and videos directly. So then we had social media videos, then we had videos and images of the people who survived and who were filming direct aftermath of the bomb. However, all that was not enough to say who is the one who did that, although we could have assumed and everything else, but for the evidentiary standards, obviously, that is not enough. And then what we decided to do is to try to analyze what was the size of the bomb that hit the theater. Then we got the architectural drawings of the theater, and we contacted a physician to create with us a model of the bomb that would make this type of destruction. And we basically we basically reconstructed the theater, and then we reconstructed the theater that has been destroyed to completely understand what was the type of destruction. And then we saw that with the help of the physician, so that was not me, who told us that this bomb is weighing more than 500 kilograms, and that likely how the impact looks, that there have been 2 bombs. So that was one step. We were confident that it was huge, 2 bombs. And then we worked with a weapons analyst that also works in my team, who then tried to look for different type of weapons that can actually fire these types of bombs. And then with the size that it was, with the military analysis around the weapons around it, military positions around it, through the help of the satellite imagery as well. But in some cases, like in this one, Russian soldiers and Russian army has also posting videos about their weaponry. Then we were able to identify that it was a specific Russian plane that had capacity to actually drop this type of bomb, and that Ukrainian army doesn't have this capacity, so they couldn't be the ones who dropped the bomb, because as you know, and as you mentioned at the end of your question, these events, sometimes in war, not sometimes, even very often, are part of disinformation campaigns. So rarely one army would say, yes, we did it, but we made a mistake. It's usually, no, it was not us, it was the other group. So that is why weapon, in many of these instances, is actually our crucial evidence. And in that case, yeah, that was the situation.
2 questions. Sorry.
2 Fragen dazu.
The first one is what you mentioned in the end, saying it could also just be a mistake. It could also be friendly fire. So you do not per se assume that whoever has the victims cannot be the perpetrator of that incident. I think that is very important. So you do question also whether maybe the Ukrainian army unintentionally hit their own. So to identify accidents and to identify false flag operations.
I think that is the most crucial and most difficult part of this job, is actually that at all times you have to be neutral. So every piece of evidence is evidence for itself, and you need to understand that despite your personal biases and despite your awareness of the situation and your previous knowledge of the situation, you need to look at every piece of evidence as an isolated evidence. And very often it happens to me, it happens to my colleagues, that just because I knew some situation, I would say, oh, in this video we see, and I can always mention the case of Iran, because this is where it's very difficult to get footage, but footage is the evidence, where you see security forces firing. So I worked on thousands of videos on Iran, and then I sent it to my colleague for a review, and my analysis was police are firing at protesters. And my colleague asked me, where do you see protesters on this video? And then I was like, oh, true. In many instances, we actually don't see on what the police and security forces are firing. So you really need to scrutinize your evidence, because this is how you build your cases. If you don't scrutinize it as a researcher, then if it leads to court, first it will never lead to a court, but then obviously defense lawyers will scrutinize it in many, many other ways. So you really need to be very rigorous into what you can actually say from videos and images. We often think it's a lot, but very often it is really, really small portion that we can reconstruct.
Wenn wir das Beispiel von Mariupol nehmen, das
let's take the example of Mariupol, the one we've just talked about.
Ich würde sagen, das erste, glaube ich, was ich vermute mal auch jeden hier im Saal.
I think that the first thing that comes to mind, that it's a lot of work dealing with such a case, examining or reconstructing the evidence. I mean, can you tell us, how long did you work on this project? How long did it take until you could say this is the case?
So that one, I think, is a month of work, but it's a big team. So it is a team of researchers that, as I said, always try to get witnesses. Then it is usually a team of open source researchers. That means people who verify videos and images. We always have weapons analysts working with us on conflicts. And then we have external collaborators, like in that case. So it was a physician, it was also an architect that worked with us to build a 3D model of the theater. And then obviously above that, once we finish our work, it goes through a very lengthy review process where you have people who work in a legal department, final review to approve the research. So that is a month. But I was yesterday on some training, and then I looked at the October 7 press release, and then I saw that we published that on October 12, which for Amnesty is very fast. So we published it after 5 days. So it depends on the complexity of the case and what do we want to prove. The case on the Lebanon journalist, for example, which was the length very similar to the Mariupol investigation, we published it after 2 months. So it does take time and resources to do it.
Ja, ich würde ganz gerne also einmal Danke sagen, tatsächlich.
Well, on the one hand, I would like to thank you. I would like to thank you for your work. I would like to thank Amnesty International. I would like to thank the ECCHR and also other organizations that work in this field. They do the work and they make sure that it's possible to make a decision and to grasp and assess the situation, because there is a permanent pressure by the public. They want to have quick results. And you need to protect yourselves from this pressure. So you have to go and say, we don't know for sure, because the verification takes time and the documentation of the case takes time. There is one more follow-up question I would like to ask, and this is concerning faked visuals. We are talking about AI a lot these days, artificial intelligence. We talk about the technical possibilities a lot. In order to produce pictures, there are lots of technologies. We saw lots of funny things in the beginning, like the Pope wearing a white coat. I mean, I'm not really good at finding out what fake is and what is not fake. I even believed the picture of the Pope in the white coat, but this is maybe also due to the Pope. So what are the recent problems, the new problems we see in view of this new technology? And what opportunities do they offer to verify certain things?
So I also believe the Pope, but maybe because it was white. But
because it was this Pope.
Exactly. First, I think the main challenge is that the content that appears online is overwhelming. So the amount of content that exists online is just huge. Like now, if you type Israel and Palestine war, for example, you will get so much, half of that garbage, and only part of it actually true information that you can work with. So that is one, I think, huge challenge for us as investigators, is actually to find credible content. But then when it comes to the fake content that has been created, it has not been created so much in wars, but I do think that is coming. It has been created mostly in elections, in different ways to manipulate the public. For wars, it's still, let's call it in a very early stage, but it's very fast developing. However, humans are still more powerful than technology. So you still can detect technology with the human eye. It is just a matter of your skills. And there are ways to determine how the picture looks like, how the video looks like, to discover that it is actually misrepresented or, in some cases, fake. There are also tools that are very simple to use and very easy, where you can upload your video or an image, and the tool will tell you, this has been fake, this has been altered in this part of the video, and this has been altered here. So in that sense, we are still, let's say, upfront this technology, and we are able to detect it. However, I think the resources that we put into technology are huge. So this is where the discrepancy is coming for. The resources of the human rights organizations and the journalists are very, very small comparing to the resources that people who develop technology have. So this is, I think, one of the key challenges, is actually like how to have skilled people who can actually recognize this at all times, at the pace that this has been developing. On a very positive note, because I said I'm optimistic, you do have, artificial intelligence can also help human rights investigators. So there are many tools that you can use to actually save the time that you need to look into certain investigation. There was a investigation, I think, published 2 or 3 weeks by New York Times, where they actually used artificial intelligence to find craters in Gaza. And the artificial intelligence tool helped them to find 1,800 craters that they believed are from bombs. And then New York Times journalists just looked at the 1,800 images and found 200 craters of bombs. If they did it without the AI help, I think it would take them probably 6 months to look into every part, in Gaza and to look for a specific crater to figure out that they're there. So definitely there are opportunities, there are challenges, but I would still say that humans are still, let's say, keeping the front of that fight.
Andreas Schüller, ich würde ganz gerne bei diesem Komplex noch bleiben, bei dieser
Andreas,
Frage
I would like to stick with this aspect for another minute, i.e. finding evidence, investigating. And I'd like to ask you about Syria and the ECCHR activities. You've been very involved in the Syria projects. You've worked a lot. From what I know, you also collaborated with forensic architecture. Now, the regime in Syria is, of course, very different from other regimes or terrorist organizations with respect to the question of shamelessness. I mean, how open do they exhibit their own violence and crimes? To what extent is this exhibition of their own violence and crime part of their own strategy? This is irrespective of whether we talk about Hamas or ISIS, but maybe also groups like Nanko, terrorist groups, narco terrorist groups. So Syria would also be an example of a regime that tried to conceal its crimes. They did not exhibit their crimes. So can you tell us more about the difference this makes and how difficult it is to prove that these regimes are violent and criminal ones? We use what Marija just described. We use all this in order to bring our cases to court and to have them processed legally and by the judiciary. Because, of course, the judges have questions and they want to see evidence and they want to hear the witnesses. Serious, that's a multi-layered thing, and it depends on which crimes you work. We focused on torture, sexual violence committed by the regime in the prisons of the different secret services in Syria, where per se you don't have much digital evidence or open source evidence, because this happens in a closed setting. So you need medical expertises and witnesses, testimonies, maybe also people who report on the groups they used to be part of. But there were cases with hundreds of victims, of dead people. You have to take samples, chemical samples from the soil, where the extent becomes visible, air raids, which can be proven. Now, in the case of torture, it's different. And of course, we had digital evidence because there were pictures taken by military photographers who had taken pictures of thousands of victims on behalf or commissioned by the regime in order to document the extent, and these pictures showed in which prisons the victims had been. And this is what we used because there was a photographer who smuggled this evidence abroad, and together with him we worked. We also had the metadata, and the metadata are the data you have with each and every picture. Like in the camera, you have the data concerning a picture so that you know when and where it was taken, and you have a lot of data you can read, and you can also upload these data, or you can also find out more about a given situation when a picture is uploaded to WhatsApp. And then, of course, we have the testimony of the photographer concerning the context and on whose behalf he took the pictures. Can you tell us what the pictures showed? Some don't know the picture, so what was the spectrum of horror they showed?
Das absolute Grauen. Es
Well, it was absolute horror.
von jedem Opfer 4, 5 Bilder
There are
normalerweise
4 or 5 pictures per victim that was taken. As I said, several thousands of corpses, dead bodies, the eyes missing or parts of the body missing, traces of torture, of beatings, lots of things you can imagine or cannot imagine. The interesting bit is that the German public prosecutor, the General Prosecutor, commissioned the Medical Institute of Cologne to have a forensic examination of each and every photograph and to index all these pictures. It was a work that took about 1.5 years. There are tons of folders with individual reports concerning each and every picture. These are proofs. This is evidence which can be used for the court proceedings in many countries, and this for a long time. And then we also have testimonies and other evidence. But we also had the data sets of these cases for the investigations in Syria.
So, in this case, I would say it is kind of a special fortune that there was somebody who could hand over this material and who gave this to you. Maybe you also have other cases where you presume that such kind of crimes are committed, as you already mentioned before, that there might be regimes or groups that do not have this bureaucratic precision of documenting one's own torture. This is a special sense of order, I would say. So maybe you can describe another case from Syria or from elsewhere. Maybe an example that shows how very difficult it can be to hold regimes or groups accountable because it is so hard to find evidence. There are many. In the context of Syria, in January, we also filed a complaint with the court about Afrin, where there were crimes committed with the help of Turkish militia that are not part of the Assad regime, but they are committing crimes against the Kurdish population. Only 20% are now remaining in the region because the rest were expelled. But there are very few images on this type of crime. And now Gaza, the German-Palestinian family Abu Jadala, the Süddeutsche newspaper reported about this case. We are in contact with the family. We know where their house was. We also got some photos sent to us. Where in Gaza? In Nuseirat. We know where it is. And Monik is another open source investigation organization in Berlin, and they analyzed all the information that we have available. On the days of the end of October, there were 300 or 400 air raids that were flown, and it is very difficult to understand who attacked, with what ammunition. Was it only this house that was attacked? Were the neighboring houses attacked as well, or were they just damaged? So you have to really work a lot with these instruments in order to find out the truth, why this was attacked. And especially with airstrikes, it is sometimes very, very difficult. Another example, you mentioned Bellingcat already. Mariupol was also mentioned, the Lithuanian filmmaker who was detained and murdered there. We had individual data on the perpetrators of the group that arrested him, a few phone numbers, a few nicknames, social media profiles, and Bellingcat then tried to find those perpetrators, track them down to find out where they are, so that the Lithuanian public prosecutor could at least issue arrest warrants against the perpetrators because their names were known. And this means that the investigation was made who were the very concrete perpetrators. And you can use individual elements to make some progress. Otherwise, you would just think, this is information only held by the military. Sometimes we don't even know who it was when nobody survived. And in those cases, this is extremely helpful. It is the combination of groups that have existed for 4 or 5 or 6 years in the ECCHR, and we have the Center for Special Technology. They will also have a major research to be published next week on Mariupol. We have Amnesty that is coming in part-times, and we also have Mnemonic and other organizations. So we network amongst each other, and we as lawyers have access to this information. We are always asked about the legal assessment about what those organizations have verified. So we kind of dovetail our activities, and then we pass this information on to the prosecutors' offices. And this also plays a role in public relations work, so that you can counter other narratives on specific events and come closer to the truth. One more question on the speed or the pace with which you investigate. In the case of the Ukraine-Russia war, the war of aggression against Ukraine by Russia, as well as in the case of the escalation of violence in Gaza at the moment, I believe that for everybody who is observing this from the outside, we all feel this sense of urgency because it is still ongoing. It is nothing that you are analyzing in retrospect, as for example in the case of the documents from Syria, where there was no possibility anymore to prevent things from happening. But at the moment, we still have a dynamic situation that is ongoing. And it gives us the feeling of urgency because we have, on the one hand, the Israeli hostages that are still held captive by Hamas, and for them every hour counts. But we also have a humanitarian catastrophe in Gaza where, as we speak, people are dying from starvation. And because you mentioned Gaza, I would like to know how you handle this, how you deal with this, that there are events where you are still discussing whether this is some kind of dynamic event that also has a genocidal momentum, if I may say it that way, or maybe it can also be described differently, but this is something which is currently being discussed in public. But even without clearly stating whether this is a genocide or not, you still feel that you don't need those definitions in order to worry about the lives of the hostages, but also the civilian population in Gaza. So whoever takes out snippets of this conversation, please do me the favor and always use the entire package, and do not just take out a snippet that sounds as if we would only be interested in one side. So how do you handle this sense of urgency? It is a major problem from the legal perspective or from the criminal law perspective, because mostly we are late, as I said. But it is extremely important to document all of this from day one. Ukraine, 24th, 25th of February, and the days before, I was already in contact with Ukrainian non-governmental organizations because they knew what they would be facing. And they told me they don't know whether it's going to start today, tomorrow, or in a week, but they wanted to be able to document from day one. And I referred them to Amnesty. And from Amnesty, I also had somebody who was referred to me. And of course, there are documentation possibilities. I said, we have this networking going on, the exchange amongst our different groups that work on the topic. And we have to say, first of all, you need to differentiate what you want to document. Is it open source? Is it witness evidence? Where do you store? Where do you save the evidence? If Ukraine would have been destroyed from day one, well, where are the servers where you would store the information? So these are very specific questions. But in the meantime, many experts, many networks have come into existence, and you can quickly have an exchange. And of course, it's different depending on the situation of the country. In Sudan, it's different from Ukraine, from Gaza. How to respond in an emergency or urgency situation to be able to store the data and then build legal cases on them. Of course, criminal law would apply later, but you can file summary proceedings with the International Criminal Court, the convention to do with genocide, for example, and there you can already do quite a lot of things and try to work with those. This does not have to do with sentencing according to criminal law, but try to prevent certain things from happening. And whether this is then actually being applied on the ground is something different. On the court matters, I would like to speak about later. Marija, Ristic. We spoke a lot about the material, about what can be obtained as evidence, geolocating, imagery, the analysis of video material. And at the start, you said, at the end of the day, especially with Amnesty, it is very important to hear the voices from the inside, from the witnesses. Abishai Margalit called this experience knowledge, so suffering that they experience themselves. And I would like to speak about those human witnesses that exist on the victim and the perpetrator side. I would also like to speak about the question, how difficult is it for them to speak about the events? What are the reasons, or good reasons, that might exist that make you not want to be available as a witness to Amnesty? Or what can be the reasons not to speak?
I think that's a very complex question. I think for many people, obviously also depend on the context. I think that very often victims don't believe that things will change, so they also don't believe the investigators, they don't believe the human rights organizations, and you mentioned this urgency, and this is what often happens for us in Gaza. For example, when we investigate airstrikes, which are very complex to investigate, and despite the fact that we know that civilians were killed, that doesn't necessarily mean it's a war crime, because it may be a military there. When you call, for example, people in Gaza, they would say, we don't want to explain what happened because we don't have food, we are expelled, we live under tent, and we don't think anyone is helping us. In many other situations, like for example Sudan, that we don't see on social media, victims are very eager to speak to the researchers because they are all in the neighborhood country, they are in Chad, they are expelled from Sudan, and in essence they feel that even this small attention is the only thing that they can help them for the world to hear. Because from Sudan we don't have images and videos, we have small, but our last report that we worked on was still based on the interviews with 50 witnesses. So our witnesses are still the gold that we have there to prove the crime. So I think it really, really depends on the situation. One other thing that I would like to mention, because we often also tend to over-document. So there are many groups that document things in parallel, and obviously there are good examples, as Andreas mentioned, when we all collaborate. But there are also examples where one person, a victim of a crime, is being interviewed by 10 organizations, by 10 journalists, by then 10 also judicial institutions as well, like national courts, international courts, regional courts. So in that sense, we also need to be aware that very often with the interviews, victims get re-traumatized. And there they need to relive all these experiences again and again. And then I know that from former Yugoslavia, we get problems in court when a victim says during one interview, something else during the second interview, something else during the third interview, not because the victim is lying, but simply because it relives that moment in different ways. Then the defense is going to absolutely destroy that testimony, and then the testimony would not be taken into account by the judicial institution.
Could also be the case that the victim, by being interviewed 10 times, somehow develops a plot. I mean, that there is, it happens to some extent, I think, to all of us if we recount certain experiences of our lives. When we tell them for the 50th time, there's not much of a change. We do, have a certain kind of way of telling an experience, and that stabilizes itself, and it's not really that we question ourselves anymore for other information.
I think actually that is the crucial thing that you said, other information. And this is where it is valuable that we have digital evidence now, because the power of digital evidence is actually to corroborate. With the digital evidence, you usually just corroborate different elements of how certain crime took place from the beginning till end, and in most of the circumstances is actually making the witness testimony stronger rather than weaker. And also, you as a researcher, if you do have strong digital evidence that potentially does not corroborate with your witness, then you are going to question your findings more rather than just relying on a witness or just relying on a digital evidence. So in that sense, I do think that it does in a way fosters the rigorous standards of the research, and that often means that you do question a witness testimony, the intention, but very often it is just trauma and how certain people see certain events. And one very important thing to that, I think, is that we need to understand that neither the witnesses, neither the social media evidence or the digital evidence tell the whole story. And this is always what I question myself at the end when I finish my investigation. Is this really how things happened? What are the things that I'm not seeing? Is my video showing everything? Did my witness actually saw everything? And was he in a possibility to see all of this? So this is something that I think every good investigator does ask, because if he doesn't ask, there will be lawyers who will be asking these type of questions.
Ich würde ganz gerne vielleicht noch ergänzen wollen. Also zum einen, ich glaube, der wichtige
In
Punkt, der
addition,
sich aus
I would like to
dem,
remind
was Sie
you
beide gesagt
that the
haben,
important
ergeben
aspect
hat,
from
ist,
what you
dass
both said is that you have to double check, you have to ask again, you have to be very stringent and rigorous in order to look at the evidence. And this is not a lack of empathy if you do this. This is not a fundamental skepticism per se, but you need to double check. You need to ask again and again in order to really give evidence of what has happened. This is what both of you have said, and that's important. I would like to also talk about sexualized violence and rape. On the one hand, because we have been dealing recently with doubts with respect to the sexualized violence on 7th October. And I think it's important to argue that the images of October 7 already show that there was sexualized violence, or there is circumstance to make us think so. And we also have to talk about what sexualized violence does and what the difficulties are with respect to the documentation and the witnessing of sexualized violence. You said you've been dealing a lot with the violence and the crime in former Yugoslavia. And we know of lots of cases, and there was a famous case which was also discussed in The Hague, sexualized violence as a war crime that happened in the place of Folter. I know the transcripts of these proceedings. I've read them, and I know the testimonies of the women who were questioned in The Hague, statements about sexualized violence they suffered themselves. And it was striking in their testimonies that they also explained why they only took the floor in the proceedings at The Hague and not before. Right now, when we talk about sexualized violence, no matter where in this world, it's important to not forget how traumatization works and how it inscribes into the bodies, but also what it means in terms of your capacity of speaking about it. So I would like to ask a question concerning this particular aspect. But before, I would like to mention a witness who, in those transcripts, touched me and impressed me a lot when she was asked by the counsel of the defense of the perpetrator, who repeatedly said, well, why haven't you talked about it earlier? You never talked about it. Did you tell your family that you were raped? And so on. And then she said, no, she didn't talk about it. She didn't tell her mother. She didn't tell her family. And she said, why should I? Given the fact what I have suffered, tell others so that they have to carry the same burden. But there was a lot of pressure on her in this cross-interrogation, as if she was inventing the truth about this sexualized violence only in that very moment. And I would like to talk about this aspect because I think that when looking at wars and sexualized violence as journalists, there is a lot of lacking understanding for the time which is needed in order to talk about sexualized violence in the first place. So can you tell us a bit about it from your own experience and about the difficulties?
I think the Folter example, which for people who don't know is a town in Bosnia that was took over by the Bosnian Serbs at the early days of the Bosnian War, and where rape was a mass crime. So a number of Bosnian Muslim women from that town were held in captivity and raped. And Folter, in that sense, is considered in terms of prosecution a success, because This is where a number of people were convicted actually for the sexual violence. But sexual violence occurred in many other places in former Yugoslavia, not only in Bosnia, it occurred in Kosovo as well. And many victims, as you said, decided very late to speak about it. I think primarily because our societies in the Balkans are very patriarchal, so the women...
Hier haben wir auch.
Well, I can speak about myself. There is a big stigma and embarrassment about that. So women are not empowered by the society to speak about that. Most of them actually hide this because they are not understood by the society as survivors, as heroes, but almost as if they had inflicted this on themselves. So in that sense, the environment where they live, it's the environment that wants to actually label them in very wrong ways. So it takes a lot of courage from that perspective to speak about that, and that everyone then knows that you are a victim of rape. And then the other thing is that at this point, which is now I think 25 or almost 30 years after the war, them speaking out is the only thing they have left. Because a lot of them hope that they are going to testify in the different trials. Some of them did testify in The Hague, and one thing to notice as well for the trials in The Hague is that most of the women that testified there were testifying as a protected witnesses. Yeah. Only few of them actually came out with their names and faces to speak about that because of this stigmatization. And now this is the only thing they have left that the public actually hears of the horror they survived. So that's why we still today have journalists in the Balkans who are publishing these types of stories, and most of these stories actually are never heard. So people were kept hiding this for years. And then another phenomenon really linked to that is children born of rape. So there are many children who were left after by their mothers because of this stigmatization and pressure. But what is a good story out of that is that these children, for example, now in Bosnia are gathered in association. So they have association of children born out of war, trying to actually challenge the society and give power to these women to actually speak about this. And last week, I think, this is why I remember that story, the founder of that association got an award, international award in US for the courage. So there are still elements of the society that do want to change this perception. And I do think that media sometimes can do a very lousy job in telling these stories, but also when they tell it in a right way, it really does change perceptions. Often it also leads to justice, it leads to cases. So in that sense, I don't think everything is black and white, but it's definitely much, much more difficult in many ways to document it than it is. We say airstrike is difficult, it is difficult, but the sexual violence, the evidence and everything related to that is far, far more complex.
Ich würde ganz gerne auch vielleicht ergänzen wollen, dass ich glaube, eine der großen Schwierigkeiten bei sexualisierter Gewalt ist,
big difficulties in sexualized violence is that there might also be differences in history. For a long time, it was such a taboo, not only that survivors did not speak about this and no victims, and there was nobody who even asked about this, and there was no interest in this. Maybe this has changed. But now, in some cases, unfortunately, this has given rise to a form of voyeurism, something that they want to explicitly show and exhibit, and this is difficult in a different way. So when it comes to finding out what happened, we really need to be very careful, very sensitive, and it also requires something that nobody can teach you. You have to be kind of tactful, and in some cases you might even decide not to describe something. Maybe something you heard, something you were told, but you have the feeling that maybe it is not suitable for an official report or a text, but it was told to me as a person. About my own work, I would always say that I have been in many situations where I had to decide to preserve something, to keep it to myself, and not to report about this immediately, not because I had my doubts whether this happened or not, but because I thought it was something the person would actually want. So the question of how to speak about this is something you always have to bear in mind as well. I am going to end this like we started this, a bit late, so don't be surprised. And in closing, I would also like to shed light on the question of jurisdiction. So which courts do we actually have right now that rule about human rights or humanitarian law standards and criminal law standards, and what are the difficulties of these courts in the way they work right now? Thank you very much. And I'm also happy to reply to this question in view of the little time that is left, because I have to say that this is a big topic. But let me comment on the previous topic before. It is very important for us to create an environment for the survivors where they can determine themselves how they want to participate in court proceedings or in other proceedings as well. So create spaces where such an exchange is possible. And I think many things have happened over the past years so that survivors are in a position where they want to actively give testimony, where they know that they are supported, and where they also want to confront the perpetrators and feel that they have the power compared to somebody maybe who is indicted in court. So to create such a space is very important, especially when it comes to cases of sexual violence, but also cases of other severe human rights violations and criminal offenses. So to create an environment where you can actively participate in criminal proceedings, where you're not an object, but you are a subject, and you're not just a piece of evidence giving testimony so that the prosecutors are supported. This is very important to see this in that context. On the question of courts, let me just make this very brief. We all know Nuremberg, the Nuremberg military courts. We also heard about the ad hoc tribunals on Rwanda and former Yugoslavia that were created in the 90s by the Security Council. And since 2002, we have had the International Criminal Court in The Hague. And it means that the ICC exists, but it only accepts cases when the states affected themselves cannot prosecute them. This according to the principle of universal jurisdiction. And the principle stipulates that for severe violations and crimes of aggression and genocide, every nation has the duty to prosecute these crimes individually. And this is why Germany also prosecuted in German courts crimes that were perpetrated and committed in Syria by Syrians against Syrians. And the reference with Germany was that many Syrian perpetrators and also many Syrian victims came to Germany. So this is a system that you have to see in its entirety. In Ukraine, for example, we have investigations that are ongoing in many countries. The evidence is then given to the Ukrainian prosecutors' offices, but also to the prosecutors' offices over here and the international courts, so that they can all work together. For Ukraine, let me ask you, because many recall Bucha and the images of Bucha, and we also had a lot of attention for this crime in this place, even though there have been numerous other crimes. So if we pick out this one crime, the question is, who investigates this? Who gathered the evidence? What are the organizations that are collecting the evidence there? And a question to both of you. Do you reckon that for this crime, in our near future, there will actually be people taken to court and sentenced? In Bucha, the Ukrainian authorities were investigating first because they had the direct access to the place of the crime. There was support by many different countries. The French said investigative teams, the US, we have the German Public Prosecutor's Office as well. So we have support by many countries for the Ukrainian documentation teams. And the International Criminal Court is also investigating. So they're also trying to distribute the cases a little bit. So the ICC is well known for the arrest warrant against Putin and the child commissioner in Russia. And then there's also another arrest warrant for the attacks on infrastructure, so the high-level perpetrators. In Ukraine, we have low-level perpetrators that are prosecuted. Let me ask you a question. We always have, one piece of evidence, right? Material evidence. This only exists once. So who decides where this is going to go? Or are they just copied, those pieces of evidence? Or do we have pieces of evidence handed around from one evidence storeroom? Or does this mean that I was born in 1967 and this does no longer exist, the evidence storeroom? Oh, wow. Bad luck then. Tough luck for me. No, because you're just saying, you have so many different groups of investigators, different prosecutors' offices. Who gets the evidence? Well, coordination is always a big problem, and the prosecutors' offices are no longer competing with each other. They cooperate, and they also agree who is going to take the lead competence or responsibility for a case. And in the past, the prosecutors always said, we are not in charge of this. And they still do this for many conflicts. They say, no, we're not doing this. Nobody wants to do this. And Ukraine, everybody wants to be involved, also for political reasons. So many things have already happened when it comes to cooperating. The cooperation of the Ukrainian Prosecutors Authority and the German Prosecutors Authority and the International Court. So do you actually think, and I can also ask you, for Bucha, do you think that persons will be held accountable for the crimes?
I do think that they will be held accountable. It is not one thing I can for sure say, that the legal processes are lengthy. That is one thing people should definitely have in mind. It takes years to build a case, and it takes years to arrest people. We spoke a lot about former Yugoslavia, but people forget this, that Slobodan Milosevic was indicted Slobodan Milosevic, for those who don't know, is a former president of Yugoslavia and basically the main person who orchestrated most of the crimes that took place in Yugoslavia, was indicted before the last Kosovo war, and it took 15 years to arrest him, but it took people who are now convicted for genocide, two Bosnian Serb, one is a general, the other is a president. It also took 15 years to arrest them. They were hiding for 15 years. At the time when Milosevic was indicted, he was considered a partner of the Western countries. So you should know that it is very obviously difficult. Yugoslavia is small comparing to Russia and Ukraine, but I do see similarities, for better or for worse, because it is happening close to Europe, or what we understand Europe. So there is bigger pressure and there's bigger resources to actually investigate these crimes one way or another. What is the problem is that we don't have these resources and efforts put in other conflicts as we have had for former Yugoslavia and that we now have for Ukraine. So this is where we end up now, where we are questioning the selectivity of international justice, which is in complete contrary to the norms that Andreas at the beginning kindly and very nicely explained. So this is where I see the problem. Obviously, there are practical problems, as Andreas said, in collaborations between different authorities, but the substance is that the international community does have resources only for certain countries and certain areas, and then doesn't want to allocate the same resources for other countries and other areas, and then rightly it does get criticism that it is actually providing selective justice.
Ich würde ganz gerne noch nachfragen, es gibt im Moment zwei Verfahren.
Let me ask you, there are two cases at the moment in which the German government is playing a special role. Both have to do with Israel and Gaza and the war there. So I would like you to explain, first of all, what these cases are and what the role of Germany is. One is the court case in The Hague, and the question that is to be answered is whether a genocide is happening there. This was initiated by the state of South Africa. So maybe you can tell us about the current status, and maybe you can also tell us about the purpose of this court case. But first of all, I'd be interested to find out what you think about the role of Germany, because in these proceedings in The Hague, before the end of the proceedings, Germany already commented and said that Germany intended to intervene as a third party in the main trial. And already called this case a political case. And the reproach of genocide that is made towards the state of Israel was qualified as being purely political. So can you tell us something about this? Because I believe that here in Germany, there was not so much discussion about this. What kind of comment was this by Germany? Because internationally, this led to quite some controversy. And there were reproaches made to the German government that in such an international proceeding to do with genocide, it had already agreed on one position or had already explained or voiced its support for one side. Maybe you can give us your assessment and tell us about the current status.
Ja, es geht das Verfahren von Südafrika gegen Israel vom Internationalen Gerichtshof, also nicht vom Internationalen Strafgerichtshof. Und der Internationale Gerichtshof ist im Endeffekt das höchste UN-Gericht. und das angerufen werden kann, zum Beispiel, wenn bestimmte völkerrechtliche Verträge, wenn es da potenziell Verstöße gegen gibt. Und die Völkermordkonvention sieht als Streitbeilegungsmechanismus vor, dass der Internationale Gerichtshof angerufen werden kann, und zwar nicht nur von den betroffenen Staaten, wobei hier ja, auch bei Palästina immer völkerrechtlich die Frage war, ist es ein Staat oder nicht? Ja. Das ist beim Internationalen Strafgerichtshof auch nochmal ein Thema gewesen. Aber auch jeder andere Staat kann den Internationalen Gerichtshof anrufen, wenn er meint, dass eine Verletzung der Völkermordkonvention droht. Und das hat Südafrika gegen Israel gemacht in dem Fall. Das geht übrigens nicht gegen die Hamas, weil die Hamas ist ja kein Staat, deshalb kann Südafrika oder irgendein anderer Staat nicht gegen die Hamas vor den Internationalen Gerichtshof ziehen. Das muss man auch nochmal unterscheiden, der ist für Staaten da.
Heißt nicht, dass die keine Verbrechen begangen haben.
Genau, das heißt nicht, dass die keine Verbrechen begangen haben, bis hin zu der Frage Völkermordkonvention oder nicht. Auch das kann man sich natürlich anschauen, aber die können nicht von den Internationalen Gerichtshof gebracht werden. Deshalb gibt es da schon mal dann auch sozusagen Schieflagen, dass halt ein Teil vom Konflikt davor landet und der andere nicht oder nur indirekt thematisiert werden kann. Und Südafrika hat halt vor allem Eilmaßnahmen beantragt aufgrund der gegenwärtigen Situation. Das hatte ich eben ja schon ausgeführt, auch zur Verhinderung eines möglichen Völkermordes. Und der Stand...
Right, this is about the ICJ case of South Africa and Israel, and the International Court of Justice decided that a genocide was imminent and Israel had to undertake humanitarian measures, and the country had 1 month's time to report to the court what they did, and South Africa added evidence and information, and they said, well, the situation is worsening, it's not getting better, and the ICJ commented on this particular claim again, and eventually there will be the main trial, but it will take about a year or two. Eventually, the court will decide whether it's proven and plausible that this is a genocide committed. Right. So far, no statement has been made by the court, so it has not been determined that this is a genocide, but that it's plausible and it can be assumed that there is a threatening genocide, which is why a number of measures have been imposed in order to avoid this genocide from happening. I wonder, why does the German government go and declare that this is a mere political trial? Well, on the one hand, it was said that the claim was not justified, but the court has stated already that it is possible to sue and to have such a trial on the basis of the Genocide Convention. 15 judges on an international scale have said that the proceedings as such is justified. Now, the German government, this was after the main trial, went and said that they will access to the trial, which is okay because you cannot join the proceedings before. But then once the main trial is on, nations can join, i.e., it's the amicus curiae statement. You support the court, you give support, you grant support to the judges. But this is not judges joining the judges, but it's experts commenting on the case. Now, the German government was, so to speak, misguided because they went and said they will join Israel, and they said that the claims were unjustified. But this is not possible legally. You cannot join the defendant, or you cannot join a party at all in such a process. And if you do so, you delegitimize the whole trial, you politicize the whole trial. You try to exercise pressure, but this is kind of anticipating in a political way and using in a political way a potential statement. So especially if you go and say, I subscribe to the international law, you need to support such a court or court hearing, and you should not comment on a proceeding and in doing so undermine the very process. This already happened at the ICC. By the way, Germany had a similar stance. In this respect, they said we will stick to our opinion no matter what the ICC says, which means we don't acknowledge and recognize what you decide, in spite of the fact that normally they support the court. So if you go and politicize, you do not really help the international law. I mean, there are lots of judicial questions which can be raised, and there may be reasons why the German government does not want to join the process. But if you go and politicize the international law, it's getting difficult. Because normally, if you go and say you subscribe to the values and to the law, you cannot do this. There is another trial I would like to comment on, and this is another intervention or situation involving the German government. This is about arms trading or arms supply to the State of Israel. Germany has been accused of delivering arms and weapons to the State of Israel. And I do see this against the background of the trial we just talked about, because this might mean a participation in a genocide. This is what people think of it, if I understand it correctly. So I wonder, what do you think about this latter trial?
So I think this distribution of arms in conflict is absolutely regulated. So as soon as you do have doubts even that your weapon that you are distributing to a party in conflict has been used for human rights violation, you should stop the weapon as a country supplying the weapon. That is regulated through the Arms Trade Treaty. So it's a special UN document that regulates it on a global level. And although you as a state, in this case Germany, do not participate in the conflict as such, but supplying one of the parties of the conflict, and there are, as I said, not even very strong evidence, but there are indication of that this weapons has been used to commit human rights violation. It is the obligation of the state, in this case Germany, to stop this weapon. We worked on a case that doesn't involve Germany, but it does involve US, where we actually proved that the US weapon killed civilians in Gaza. So we found the remnants of the weapon on the ground. We interviewed witnesses. We interviewed families of the victims. And then we traced this to the trade data and understood when it was produced in US, who from US approved this, and how it went. So this is clearly violation of the Arms Trade Treaty. Germany is also violating Arms Trade Treaty, although we still don't have a piece of weapon used to kill someone, but we are aware that the Israeli government is massively violating human rights using different types of weapons. So in that sense, in other circumstances, Germany would withdraw its supplies to the countries. This is obviously, as Andreas explained, very, very political. So I think these are the reasons why it is not. But in any other circumstances, Germany would be the first to say, we are not supplying the weapons there.
Ja, aber ich finde, dann sollte man sozusagen das Argument vielleicht auch der Bundesregierung
but then
auch erwähnen, warum
you should
in diesem
also
Fall.
mention the argument used by the German government. They say why they deliver. They say they want to furthermore deliver arms and they want to protect Israel because of the historical responsibility in view of the German history and the crimes committed here. So why doesn't this matter, or what relevance does this information have? I mean, seeing oneself in a special historical responsibility. That is what Germany does, protecting Israel for historical reasons. Also, under the aspect of the right of existence of Israel, which is being threatened. So what importance does this reference to the history have, or would you say that in view of the international law, history or this history cannot matter? How would you answer my question? I think you have to even you have to differentiate even more what arms or what part of arms were delivered before 7th October, which weapons have been delivered ever since, and what is asked from the German weapons industry, because Israel wants to buy. To speak about arms trade in general does not really help us here. But this is about ammunition for a certain tank, which is different from small weapons or ammunition for guns, which can also be used by the police. So you have to differentiate and you have to look at the international law and 7th October and Israel's reaction. The humanitarian international law is being violated too, we say. And there are lots of reasons to doubt that Israel is complying with the international law. So we have to see what weapons are being delivered and were there was there the license to deliver them already. But it remains a conflict, right? It remains a conflict which is due to a concrete attack and in which we see a reaction to the violence now. I think it's also clear that different parties and different perspectives also become evident in its difference in terms of time. I mean, do you start telling the story after 7th October, or does history begin before? This is also depending on different perspectives of different parties or of the different parties involved. But then you cannot simply go and take October 7th out of the overall calculation. You can take history out of the overall calculation either. So I would like to ask once again, what status does our history and our guilt have in this particular context?
When we look at this conflict, I think this is an essential element. And associated with this is the respect for international humanitarian law. Discussions are ongoing about how much this has been violated, but we learn from our history that international law was developed a lot after World War II. It is protecting many people, especially against the backdrop of the crimes committed by the Nazis. The international law convention, genocide convention, etc., exist because of the Holocaust and the crimes. And therefore, it is very important in such a heavily politicized conflict that we need to respect the law. And for this, we might also have to refer to the courts, and they should decide who is right, legally speaking, but you really need to make sure you respect the legal standards in the way you react towards Israel and also towards Hamas. Hamas could also stop the conflict at any time by releasing the hostages, for example. But all of this needs to be covered and framed by international law, and you cannot just push this aside or ignore international law. And this is especially a learning from German history, that you should not ignore this, push this aside, but that one essential factor is how you behave and how you support Israel. And of course, it is reminded that international law has to be respected, but it is said in such an abstract way. It's kind of a standard phrase, and it's not really substantiated. And we believe it has to be substantiated because there are some doubts whether international law is respected all the time. So thank you ever so much. At this juncture, I think, at least for me, speaking about these questions is not so easy. I also think what we have tried here today, namely trying to ask systematic questions, trying to discuss standards and norms and the way they are applied, and all of this is not easy when we know that people are dying as we speak. Sometimes it feels very sober and very neutral, and I hope that it was clear that this has nothing to do with a lack of empathy or a lack of urgency that we feel, but still I think that analyzing in such a way is needed. We need this type of analysis because in our private spaces and public spaces, we are constantly confronted with situations where pain speaks, where desperation speaks, and all of this is, of course, justified. But at least for me, it is very helpful in those moments to understand people's plight, but also have the analytical tools available in order to try and analyze these concrete situations with abstract norms and principles. So I would like to invite, if you still want to ask the audience to ask questions, but before that, I would like to ask you too. Despite the violence that we are experiencing currently, what is hope inspiring for you? You said before that you're an optimist, so let me start with you. Anything that is inspiring hope for you right now?
Well, we spoke about now ECCHR in Germany and Israel. And for me, courts are inspiring, and they are justice, not maybe the way I want to see it, but they are definitely the venue where our work gets most satisfaction, because in most of the cases that is also satisfaction for victims, because this is why we in essence are documenting the crimes. And in the discussion around hope and how courts are important, for example, I saw a very interesting thing last week, an article, how actually people before Israel and Palestine case, a lot of people never heard about International Court of Justice. They never knew what is the court, what do they do?
Okay, aber die Latte liegt jetzt natürlich echt niedrig. Ja,
well, that is a very low bar.
No, that's a really low bar for hope.
But I think that is actually very true what you said. The bar for hope in fact-finding for war crimes, it is low, but there is a bar.
Okay.
And as I said, it takes time, it takes patience, but I really, really do believe in the system. And the criticism we put today is also to make the system better. So I do think that although we said a lot of very disturbing things today, people will come out of this believing that the justice is possible, because this is really what drives me personally, despite everything. Yeah.
Andreas Schüller?
Ich glaube, die Hoffnung,
I
die
think that
ich
the
habe,
hope
das kommt
I
aus vielen
have
Gesprächen mit
comes from many different conversations I had with persons affected, colleagues who work like we do worldwide, but in completely different circumstances. For instance, that came out of Gaza. We had Palestinian colleagues who we trained, and we had to enable them to leave Gaza. And when we discuss with them, they already think about where to file which case, and they know that Gaza, the way they knew it, is over. They try and reorient themselves, and they say that law and justice is something we still believe in, even though that some have already given up hope on justice as well. And the same goes true for Ukraine, but also Colombia, Afghanistan, Myanmar. Whenever you speak to people there, they believe in humanitarian law as well as international criminal law. This is something that exists, and not only on paper. It is enforced more and more. And this is an anchor that we want to hold on to. Because if this did not exist, only politics or only the right of the stronger, of the survivor, where would we end? In the last 5 to 6 or 7 years, things have become worse, but it really makes our work even more important in those global networks to collaborate, to come together in an interdisciplinary way with lawyers, with non-governmental organizations, in order to find out what we can do using international law. It was developed in 1945 at the latest, and how can it be used today? I can also say what is hope-inspiring for me, and this is that there are persons and organizations like you who are actually devoting this accuracy and patience that is needed in order to be certain when it comes to investigating facts, but also with this kind of universal perspective, wanting to investigate every individual crime and every individual person, and believing that these persons and cases and groups are equal in front of the justice system. So thank you so much to you both for this very interesting conversation. And if you still have the stamina, we would like to take some questions, and it is very important that you wait until a microphone reaches you.